Five questions were referred to us for consideration. We'll now read out the questions and the answers. Question number 1. Are the grounds specified in Article 19(2) in relation to which reasonable restrictions on the right to free speech can be imposed by law exhaustive? Or can restrictions on the right to free speech be imposed on grounds not found in Article 19(2) by invoking other fundamental rights? Our answer is the grounds lined up in Article 19(2) for restricting the right to free speech are exhaustive. Under the guise of invoking other fundamental rights or under the guise of two fundamental rights staking a competing claim against each other, additional restrictions not found in Article 19(2) cannot be imposed on the exercise of the right conferred by Article 19(1)(a). Question number 2. Can a fundamental right under Article 19 or 21 of the Constitution of India be claimed other than against the state or its instrumentalities? Our answer is a fundamental right under Article 19(21) can be enforced even against persons other than the state or its instrumentalities. Question number 3. Whether the state is under a duty to affirmatively protect the rights of citizen under Article 21 of the Constitution, even against a threat to the liberty of a citizen by the acts or omissions of another citizen or private agency. Our answer is the state is under a duty to affirmatively protect the rights of a person under Article 21 whenever there is a threat to personal liberty, even by a non-state actor. Question number 4. Can a statement made by a minister traceable to any affairs of state or for protecting the government be attributed vicariously to the government itself, especially in view of the principle of collective responsibility? Our answer is a statement made by a minister, even if traceable to any affairs of the state or for protecting the government, cannot be attributed vicariously to the government by invoking the principle of collective responsibility. Question number 5. Whether a statement by a minister inconsistent with the rights of a citizen under Part 3 of the Constitution constitutes a violation of such constitutional rights and is actionable as constitutional tort. Our answer is a mere statement made by a minister inconsistent with the rights of a citizen under Part 3 of the Constitution may not constitute a violation of the constitutional rights and become actionable as constitutional tort. But if, as a consequence of such a statement, any act of omission or commission is done by the officers resulting in harm or loss to a person or citizen, then the same may be actionable as a constitutional tort. That's how we have answered this question. Now that we have answered the questions, the writ petition and the special leave petition are directed to be listed before the appropriate bench after getting orders from the Honorable Chief Justice of India.
I have had the benefit of reading the erudite judgment proposed by His Lordship P. Ramasubramanian J. While I agree with the reasoning and conclusions arrived at by His Lordship on certain questions referred to this bench, I wish to lend a different perspective to some of the issues by way of my separate opinion. The concern of the petitioners in these such as women who may be victims of crime. Such indiscreet speech is a cause of concern in recent times, as it is thought to be hurtful and insulting. The questions raised in these matters are with regard to remedies available in law, so as to counter such kind of hurtful or disparaging speech made, particularly by the public functionaries. I've gone to the prayers sort. Ahead, I've put a table where the questions have been referred, His Lordship's views, that is now the majority's views, and my views. Question number 1. Are the grounds specified in Article 19.2 in relation to which reasonable restrictions of the right to free speech can be imposed in law exhaustive, or can restrictions on the right to free speech be imposed on grounds not found in Article 19.2? For an analysis of the content of Article 19(1)(a) of the Constitution, which grants to all citizens of India the right to freedom of speech and expression. Before proceeding to analyze the relevant constitutional provisions, it may be appropriate to preface the discussion with the thought that freedom of speech is not contingent only upon the laws of a nation. The compulsion of social relations and the informal pressures of conformity exerted in a pervasive manner determine to a great extent the content and limits permissible speech in society. It is the laws, however, through their own unique methods, which reinforce social sanctions. Therefore, the Constitution, which is the fundamental law of the land, as well as the other laws which are measured on the touchstone of the Constitution, are to be interpreted, having regard inter alia to the content and permissible limits of free speech in a peaceful society. I've given Article 19(1)(a) and 19(2) an overview. For a country like ours, which is a parliamentary democracy, freedom of speech and expression is a necessary right as well as a concomitant for the purpose of not only ensuring a healthy democracy, but also to ensure that the citizens could be well informed and educated on governance. The dissemination of information through various media, including print and electronic media, or audiovisual form, is to ensure that the citizens are enlightened about their rights and duties, the manner in which they should conduct themselves in a democracy, and for enabling a debate on the policies and actions of the governments, and ultimately for the development of the Indian society in an egalitarian way. I have referred to some of the decisions on right to freedom of speech and expression, such as Ramesh Thappar versus State of Madras, S. Kushbu versus Kaniyammal, Shreya Singhal, etc. But the present cases, however, are not really concerned with the restrictions on the right to freedom of speech being imposed by the state. These cases are concerned with the content of Article 19(1)(a) of the Constitution, inasmuch as the grievance sought to be ventilated by the petitioner is whether there could be an inherent constitutional restriction on freedom of speech and expression on the citizens in relation to other citizens. These cases are not with regard to reasonable restrictions that could be imposed by the state or the freedom of speech and expression. Rather, what would be the content of free speech that should not be exercised as a right by an individual, which would not in any way give rise to cause of action to another citizen to seek a remedy. I have adverted to various aspects of content of speech, such as right to circulate, right to dissent, right to advertise, etc., which I need not go into. Then I have adverted to the decisions of this court with regard to hate speech. There are 2-3 decisions, such as the Pravasi Bhalai Sangathan versus Union of India, at Amish Devgat versus Union of India. I did not go into all those, and have extracted various sections of the IPC, Indian Penal Code, Criminal Procedure Code, Protection of Civil Rights Act 1955, Religious Institutions Prevention of Misuse Act 1988, Scheduled Castes and Scheduled Caste Tribes, Scheduled Tribes Prevention of Atrocities Act, Representation of People Act, the Cable Television Network Regulation Act, and the rules made thereafter, Cinematograph Act, Information Technology Act, norms of journalistic conduct 2010, etc., with regard to the procedure of law. Then I have said, with regard to an aspect beyond hate speech, theoretical and doctrinal underpinnings justifying restraint on derogatory and disparaging speech may be treated to two primary factors: human dignity as a value as well as a right, the preambular goals of equality and fraternity. I have discussed about them with reference to various cases in the international practice, that is from Canada, Australia, South Africa, Germany, and then about the Indian cases, Charu Khurana versus Union of India, Indre noise pollution, K.S. Puttaswamy versus Union of India, and then the preambular goals of equality and fraternity. Equality, liberty, and fraternity are the foundational values embedded in the preamble of our Constitution. Hate speech, in the sense discussed above, strikes at each of these foundational values by marking out a society as being unequal. It also violates fraternity of citizens from diverse backgrounds, the sine qua non of a cohesive society based on plurality and multiculturalism, such as in India, that is Bharat. Fraternity is based on the idea that citizens have reciprocal responsibilities towards one another. The term takes within its sweep inter alia the ideals of tolerance, cooperation, and mutual aid. I have given various aspects on the content of the word fraternity with reference to Subramanya Swamy versus Union of India, which is a decision of this court. And I have referred to fundamental duties under Part 4A of the Constitution as a means to check disparaging and unwarranted speech, particularly under Article 51A, Fundamental Duties. It shall be the duty of every citizen of India to uphold and protect the sovereignty, unity, and integrity of India, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional and sectional diversities, to renounce practices derogatory to the dignity of women, to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. Fundamental duties also constitute core constitutional values for good citizenship in a democracy such as ours. The duties enumerated above enjoin all citizens with the obligation of promoting fraternity, harmony, unity, collective welfare, etc. Then, in the context of the speech of public functionaries and other persons of influence and celebrities, having regard to their reach, real or apparent authority, and the impact they wield on the public or on a certain section thereof, owe a duty to the citizenry at large to be more responsible and restrained in their speech. They are required to understand and measure their words, having regard to the likely consequences thereof on public sentiment and behavior, and also be aware of the example they are setting for fellow citizens to follow. In this regard, I would like to quote what I have stated at the very beginning. One of the Indian philosophers, Basaveshwara, and the English translation of it is, one should speak only when the words uttered are as pure as pearls strung on a thread, like the luster shed by a ruby, like a crystal splash that cleaves the blue, and yes, and such that the Lord, on listening to such speech, must say, yes, yes, that is true. I may also quote from verse 15 of chapter 17 of Srimad Bhagavad Gita, where the English translation says, words that do not cause distress are truthful, inoffensive, pleasing, and beneficial, are said to be included within the discipline of speech and are likened to regular recitation of the Vedic scriptures. This is called discipline of speech or Vagmaya Tapas. The discussion presented herein above is with a view to rekindle some ideas on the content of Article 19.1a. of the Constitution and on other pertinent issues surrounding the right to free speech guaranteed under the aforesaid article. However, as far as the substantial analysis of question number 1 is concerned, I respectfully agree with the reason and conclusion proposed by His Lordship Ram Subramaniam J. Question number 2. Can a fundamental right under Article 19 or 21 of the Constitution be claimed other than against the state or its instrumentalities? I have quoted His Lordship Justice Matthew in Keshavananda Bharati, then His Lordship Justice H.R. Khanna in ADM Jabalpur versus Shivkant Shukla, which is a dissenting opinion, and His Lordship Justice Chandrachud, as he then was in Puttaswamy's case, that the right to speech is an inalienable right of man and that the fundamental rights are only recognition of that rights. What emerges from the aforesaid decisions of this court may be culled out as follows. I have given my 3 points on that. With that primer, I shall proceed to consider whether the fundamental rights under Article 19 and 21 of the Constitution can be claimed against any person other than the state or its instrumentalities. With historical and political changes and the advent of democracy and of constitutional government, the state was created under and by a constitution and placed at a position which renders it capable of interfering with natural and common law rights. I have given a discussion on the common law rights and what are known as the natural rights and the fundamental rights. For saving the time of the court, I will not highlight on all of them, but I'll only say this. It has therefore been unequivocally declared by this court that while the content of a right recognized under Part 3 of the Constitution may coincide or overlap with the common law right, the remedies available against violation of the respective form of right operate in different spheres of law. That is, although the content of a common law right and a fundamental right may be almost identical, the remedy against violation of a common law right shall lie under common law and not under the Constitution. Similarly, the remedy against violation of a fundamental right is provided for under the Constitution itself expressly against the state under Article 92 thereof. I have given the difficulties which would be faced if a fundamental right under Article 19 and 21 is permitted to operate horizontally so as to seek the remedy by way of a writ petition before a constitutional court. I have stated all those, such as a writ petition cannot be entertained when there are disputed questions of fact. A writ petition cannot be entertained against private persons as such. But I have one submission which I have stated here when it comes to a writ petition and the operation of Article 21 in the context of habeas corpus. Before that, I would like to give this illustration. Let me assume for the purpose of argument that the fundamental right under Article 19(1)(a) read with Article 21 is allowed to operate horizontally. A person would then be eligible to file a writ petition against another private individual or entity for violation of such right. The violation may, for instance, be a verbal attack at the aggrieved person, which may have the effect of undermining such person's dignity or reputation. Dignity and reputation are essential facets of the right to life under Article 21. At the same time, they are also recognized as common law rights, as they are fundamental attributes of human personality, which is regarded as a supreme value in common law. Common law remedies, including declarations, injunctions, and damages, are available to redress any injury to common law rights, including the right to dignity and reputation. Such rights are also statutorily recognized under the Specific Relief Act 1963 and the Indian Penal Code. Therefore, on account of availability of an alternate remedy under common law, the courts would be reluctant to entertain a writ petition under Article 226 or 32, as the case may be. Then I come to the habeas corpus remedy. However, there is another aspect of the matter that requires to be discussed. A writ of habeas corpus is an order directing the person who has detained another to produce the detainee before the court in order for the court to ascertain on what ground or for what reason he has been confined. A writ of habeas corpus is granted ex debitio justitiae, and the applicant must only demonstrate prima facie unlawful detention of himself or any other person. If there is no justification for the detention and the same is unlawful, a writ is issued as of right. The importance of a writ of habeas corpus is the duty being cast on a constitutional court to issue the writ to safeguard the freedom of a citizen against illegal and arbitrary detention. In my humble view, an illegal detention is a violation of Article 21 of the Constitution, irrespective of whether the detention is by the state or by a private person. Therefore, in the context of the remedy of writ of habeas corpus, which is available under Article 226 as well as under Article 32 of the Constitution, I have said that the Article 21 would operate horizontally. I have cited certain decisions where this court has exercised jurisdiction under Article 32, read with Article 142, and granted compensation in certain matters where Article 21 was invoked. In light of the aforesaid discussion, question number 2 is answered as follows. The rights in the realm of common law, which may be similar or identical in their content to the fundamental rights under Article 19 or 21, operate horizontally. However, the fundamental rights under Articles 19 and 21 may not be justiciable horizontally before the constitutional courts, except those rights which have been statutorily recognized and in accordance with the applicable law. However, they may be the basis for seeking common law remedies, but a remedy in the form of writ of habeas corpus, if sought against a private person on the basis of Article 21 of the Constitution, can be before a constitutional court, that is by way of Article 226 before the High Court or Article 32 read with Article 142 before the Supreme Court. Question number 3, whether the state is under a duty to affirmatively protect the rights of a citizen under Article 21 of the Constitution of India, even against the threat to the liberty of a citizen by the acts or omissions of another citizen or private agency. In that context, I have referred to certain decisions of this court in the context of Article 21, where compensation, etc., was granted by this court and the writ petitions were entertained, and have given that in order to protect life and liberty, what the role of the state would be, where inaction on the part of the state to contain a hostile situation between private actors would have the effect of depriving persons of the right to life and liberty, where the state had failed to carry out its obligation under a statute or a policy or scheme, and such failure could have the effect of depriving persons of their right to life and liberty. It is therefore clear that the acknowledgement of this court of the duty of state under Article 21 only pertains to a negative duty, not to deprive a person of his right to liberty and life, except in accordance with law. This court has not recognized an affirmative duty of the state under Article 21 of the Constitution to protect the rights of a citizen against a threat to the liberty of a citizen by the acts or omission of another citizen or private agency. In light of the above discussion, question number 3 is answered accordingly. Then, can a statement made by a minister, next, question number 4, can a statement made by a minister traceable to any affairs of the state or protecting the government be attributed vicariously to the government itself, especially in view of the principle of collective responsibility? A minister may make statement in 2 capacities. First, in his personal capacity. Second, in his official capacity and as a delegate of the government. It is no brainer that in respect of the former category of statements, no vicarious liability may be attributed to the government itself. The latter category of statements may be traceable to any affair of the state or may be made with a view to protect the government. If such statements are disparaging or derogatory and represents not only the personal views of the individual minister making them, but also embody the views of the government, then such statements can be attributed vicariously to the government itself, especially in view of the principle of collective responsibility. In other words, if such statements are endorsed not only in the statements made by an individual minister, but also reflective of the government stance, such statements may be attributed vicariously to the government. However, if such statements are stray opinions of an individual minister and are not consistent with the views of the government, then they shall be attributable to the minister personally and not to the government. Accordingly, I have answered question number 4. Question number 5, whether a statement by a minister inconsistent with the rights of a citizen under Part 3 of the Constitution constitutes a violation of such constitutional rights and is actionable as constitutional tort. Where public law and private law are in theory treated as analytically different, in practice the divide between the two spheres is often blurred. As a result, ideas, concepts, and devices from one sphere influence the other. Such an intermingling has given rise to the doctrine of horizontal effects, as discussed herein above, wherein a constitutional directive or norm, fundamental right, is interpreted by courts to apply between individuals. Then I have given, in the context of constitutional tort, whether the writ petition is maintainable and with regard to the principles which would apply to entertainment of writ petitions. In this regard, I have referred to Article 294B of the Constitution, which declares that liability of the union government or the state government may arise out of any contract or otherwise. The word otherwise implies that the state liability may arise for tortious acts as well. Article 300 enables institution of appropriate proceedings against the government for enforcing such liability. Article 21 has played a significant role in shaping the law on tortious liability of the government. This court has asserted that the concept of sovereign functions, which acts as an exception to attracting tortious liability, ends where Article 21 begins. Therefore, this court has been willing to defend life and liberty of persons against state lawlessness by holding that where Article 21 is violated, the state has to pay compensation, and the concept of sovereign function does not prevail in this area. This is particularly so in public interest litigation. I have referred to these cases, including Nilapati Behera versus State of Orissa and other cases, Rudal Shah, D.K. Pashu, etc. In light of the above discussion, it is observed that it is not prudent to treat all cases where a statement made by a public functionary resulting in harm or loss to a person or citizen as a constitutional tort. Regard must be had in every case to the nature of resultant harm or loss. Further, it is to be noted that even the cases cited above have permitted treating an act or omission as a constitutional tort where there has been an infraction of fundamental right as a direct result of such act or omission. Therefore, the causal connection between the act or omission and the resultant infraction of fundamental right is central to any determination of an action of constitutional tort. Therefore, it is observed that presently invocation of writ jurisdiction to grant damages by treating acts of omissions of agencies of the state as constitutional torts must be an exception rather than a rule. The remedy before a competent court or under criminal law is in any case available as per existing legal framework. Accordingly, I have answered. In light of the above discussion as well as the answers given to the questions referred, the following other conclusions are drawn. It is for the Parliament in its wisdom to enact a legislation or code to restrain citizens in general and public functionaries in particular from making disparaging or vitriolic remarks against fellow citizens, having regard to the distinct and strict parameters of Article 92 and bearing in mind the freedom under Article 19(1)(a) of the Constitution. Hence, I am not inclined to issue any guideline in this regard, but the observations made herein above may be borne in mind. B. It is also for the respective political parties to regulate and control the action and speech of its functionaries and members. This could be through enactment of a code of conduct, which would prescribe the limits of permissible speech by functionaries and members of the respective political parties. C. Any citizen who is prejudiced by any form of attack as a result of speech or expression through any medium targeted against her or him, or by speech which constitutes within quotes hate speech or any species thereof, whether such attack or speech is by a public functionary or otherwise, may approach the court of law under criminal and civil statutes and seek appropriate remedies. Wherever permissible, civil remedies in the nature of declaratory remedies, injunctions, as well as pecuniary damages may be awarded as prescribed under relevant statutes. However, answers given to question numbers 4 and 5 may have a bearing in the context of collective responsibility of government and constitutional tort. Writ petition and civil petition are directed to be listed before an appropriate bench after seeking orders of Honorable the Chief Justice of India. I must thank my honorable brother judges and the audience for your attention, particularly the lawyers.
अपलोड कर देंगे ठीक है
One or two typos are